Hi there. Welcome to Relitigated, the show where five friends who are absolutely not lawyers attempt to retry a real Supreme Court case. I'm your host, Nikki, and this is episode 11, Colorado versus Connelly. Two quick notes before we get started. First, as always, we try our best to represent the facts and decisions in the case as accurately as possible, but we're not lawyers, and nothing in this episode should be taken as legal advice. Second, if you enjoy the podcast, please support us by subscribing, rating, leaving us a comment, and telling your friends. We could really use the help in getting the word out. If you like, you can also find us on YouTube, Instagram, and Blue Sky. Our handle is @RelitigatedPodcast. Thank you so much for your support. With that out of the way, let's start the show.
A peruke is what the old-timey powdered wig is called.
Peruke?
A peruke, a man's wig, particularly the popular type from the 17th to early 19th century, made of long hair, curls on the sides, drawn back on the nape of the neck. Exactly what I had in mind.
Mm-hmm. Wow. I can't imagine a better place to start than that.
Perfect.
Well, in that
Play
case...
us in, keyboard cat.
So, hi there. Welcome to the Relitigated Podcast. I am your host, Nikki, and I am joined by my co-host, Jarrett. Hello, Jarrett.
Hello.
We also have with us three friends who will be role-playing as our justices. First, we have Associate Justice Graham.
Good evening. Happy to be here.
Next, we have Associate Justice Mike.
Yo.
And lastly, we have our Chief Justice, Adam.
Ooh, I promised I wasn't going to let this go to my head, but when you call me Chief Justice, it's intoxicating.
So if you're new to the show, here's how this works. Jarrett and I have selected a real Supreme Court case, and our justices do not know what case we have selected. Jarrett will introduce the case to us and walk us through the facts so we can all get familiar with the details. The justices are free to ask factual questions during this time, and we will answer as best as we can. Next, we'll move into oral arguments, where Jarrett will roleplay as the petitioner, and I will roleplay as the respondent. We each get 7 minutes to make our case, during which the justices can interrupt us and ask probing questions. When the arguments are over, the justices will deliberate and deliver their own opinions. The final rulings do not need to be unanimous. Majority opinion wins. Even if two or more justices agree in principle, they can disagree as to why. Once we've had our fun with our mock hearing, Jarrett and I will reveal what the Supreme Court actually decided and talk about how we feel about the actual results and why this case matters. Sound good to everyone?
Roger that.
Huzzah.
Let's do it.
Great. Now I'm going to turn it over to Jarrett.
All right. Thank you much. Before I start, I do want to give a shout out to William Pizzi. I hope I'm pronouncing that correctly. He's the gentleman who wrote the article from which most of the facts that you're about to hear. So I did want to give a shout out real quick. So here we go. The case that we're going to discuss for this episode is Colorado v. Connelly. This case begins one day on the street outside a courthouse in Denver, Colorado, where a gentleman named FC walked up to a uniformed police officer, stuck out his hands, and asked to be arrested. The officer asked FC why he wanted to be arrested, and FC allegedly responded, quote, "I killed someone." When the officer asked FC to explain further, FC said that he had stabbed a 14-year-old girl to death several months prior and described where in the city he had done so. At this point, the officer read FC his rights, handcuffed him, searched him for weapons, and called for a detective to come to the scene. While waiting for the detective to arrive, FC was informed by the officer again that he did not have to talk to the police. Undeterred, FC described more details about the victim, including her name, her age, and that they had traveled to Denver from Boston together. FC even offered to take the officer to the location of the alleged murder. In response, the officer asked FC if he was currently under the influence of alcohol or drugs, but FC reported that he was sober. When asked if he had ever been treated for a mental illness, FC confirmed that he had in fact been hospitalized 5 times. When the detective arrived, he requested that FC return with him to police headquarters for questioning, and FC agreed. At police headquarters, FC once again was read his rights and once again chose to discuss the murder. In the ensuing interview, FC repeated much of what he had said on the street, as well as added some additional details about the incident, including how he and the victim had traveled by bus from Boston together before getting into an argument that led FC to stab the girl. FC made good on his offer to take the officers to the scene of the crime, directing them from a police vehicle through the city and to an alley. It was in this same alley several months earlier that the body of a 14-year-old girl with multiple stab wounds had been discovered. Following FC's interview, the police conducted a full investigation, including traveling to Boston to prove the identity of the victim and the connection between her and FC. Through their work, they found the family of the young girl, positively identified her clothing, her name, and her disappearance, confirmed a match of her dental records, and confirmed with FC's family that he and the girl were seen together at a family function. With this corroboration of FC's story, he was formally charged with the crime of second-degree murder. While the police were investigating in Boston, FC was hospitalized at a state mental hospital. It turns out that before the end of the day on which he admitted to the murder, he had to be restrained and treated by a psychiatrist in the jail. In a meeting with the public defender, he was considered delusional and confused. FC described hearing the voice of God that commanded him to confess. After an examination, FC was ruled to be incompetent to stand trial and committed to the Colorado State Mental Hospital. It wasn't until 5 months later that a doctor at the hospital opined that FC was once again competent to stand trial. Ahead of the trial itself, FC's lawyer filed a motion to suppress his statements to the police on the day that he confessed to the murder, arguing that his mental illness meant that he was not capable of making a voluntary admission, which meant that his confession was, in fact, involuntary. They further argued that since the confession was involuntary, admitting it into evidence would violate FC's due process rights. The officer and the detective testified that FC did not present to them as a man in the throes of a mental illness. They noted that he was neatly dressed, spoke normally, and appeared to be in control of himself. They followed all of their procedures, including reading FC his rights numerous times, thus giving him multiple opportunities to remain quiet. The psychiatrist at the state psychiatric hospital testified that FC had reported hearing the voice of God demanding that he confess to the murder. He flew back to Denver that night, following the command of the voice in his head. FC stated that he was not actually interested in confessing and had gone to the airport a few times with the intent of returning home. It wasn't until the voice told him to confess or kill himself that FC chose to confess. From here, FC reported that he followed the commands of the voice, including sending his remaining money home to his mother, which his mother confirmed she received. As a result of FC's story and his mother's corroboration, it was the opinion of the psychiatrist that FC suffered from schizophrenia, which caused command auditory hallucinations. While FC could function normally most of the time, he didn't have a choice in confessing, according to the psychiatrist. Ultimately, the trial judge ruled that FC's statements were not given voluntarily because they were not the result of his free will, and so they could not be entered into evidence and used against him in court. Furthermore, any evidence collected as a result of FC's statements also needed to be suppressed. This includes basically everything. Since this ruling essentially obliterated the prosecution's case, they appealed to the Colorado Supreme Court, but the trial court's decision was upheld. Undeterred, the prosecution once again appealed, this time to the United States Supreme Court. So now the question falls to our panel of justices. Did FC's mental illness mean his statements to the police were involuntary, and their use at trial would be considered a violation of his due process rights?
Not taking it easy on us.
Welcome back.
Oh man, I was hoping for another poop case.
That's like, yeah, I just wanted, like, man steals candy from child and they executed him the next day. Were they hasty? Should they have waited a week? Like, that's the kind of case I want to talk about. We're not even talking about guilt or innocence in this one. This is crazy. This is like second derivative right violations. Oh
Yeah, because I mean,
boy.
like, pretty much everyone's sure that he did it, right? Like, that's
Oh, that's the thing. That doesn't even matter. That's not even in scope for us. But I digress. Sorry,
Yeah.
we've only heard half the case. We're so quick. We're so quick to jump to our jurisprudence. We're just so excitable once you put these wigs on us.
Are there any factual questions I could address?
Um, what happened in the 5 months that he was in the psychiatric facility? Do we have any info on that?
He was presumably getting treatment and
They're just
having
shocking him every day.
his mental status was getting stabilized. So he was receiving treatment in the hospital.
was that like to with the express of making sure that he was like competent enough to stand trial, or I mean, because it seems like the case could have gone to trial pretty quickly based on
They were tuning the amperage
everything.
specifically to get him trial ready. Yes.
If he's incompetent, then the case cannot move forward. The trial cannot move forward. He has to be competent and able to proceed and participate. So while he was in the hospital, they were basically paused and waiting for him.
Okay, and it took them 5 months or 7 months to determine that no, he can't go to trial.
No, after the end of was it 7 months, Jarrett?
I believe it was he spent 5 months in the hospital before a psychiatrist opined
Yeah.
that he was now competent to stand trial.
So he
Okay.
underwent the treatment, was reevaluated, and then
Gotcha.
opined competent, and then the judge, I would presume, found him competent at that point.
Okay, so they find him competent, and then when did it switch back to incompetent?
It didn't.
Yeah, it was when he was like
Or is it
charged.
Retroactively, it doesn't matter that you're competent now. You weren't competent back when you confessed.
That is the assertion of the defense. So he confessed, and then that night he had problems. He decompensated. And then the following day, I believe it was, he met his defense lawyer for the first time, and the defense lawyer had concerns. And then that led to the initial competency evaluation and his determination that he was incompetent.
Was the fact that he had an episode or whatever, I don't know what that he had some sort of, it became obvious that something was going on the day that he was arrested. Is that relevant, or are we saying that he can never be seen as competent at any point because he has chronic schizophrenia?
He was assessed as competent following his treatment and stuff. I think the issue was just it turned out that at the time that he was confessing, he hadn't been treated and was acutely ill, and that became evident, in the hours that followed.
So if he was not acutely ill in the hours that followed, but was acutely ill at some point, maybe days later when it wasn't relevant, there would be no case here.
I mean, it's up to the defense to really,
Gotcha.
make that assertion.
Yeah, because maybe I could see, like, I confessed, and then I went a little crazy because, oh my god, I just confessed to murder and showed the police where the body was and gave them all the evidence.
They need to do a no take backsies on confessions. Yeah, that's what's missing.
Yeah.
I
I think that there's just one thing to clear up because competency the competency was he competent to stand trial? Competency doesn't have anything to do with the confession, as I understand it, right? So competency is a legal term, and so what I want to make clear is he confessed. The question isn't was he competent to stand trial. That was just what delayed the case from going to trial. The question really is, can the state use his confession if he was potentially not in control of himself when he confessed?
But he did confess to a thing that he seems to have actually done without anyone forcing him to confess to the thing that he actually potentially did.
Yeah, it's, potentially, right? To be fair, at this point, there has not been a trial that has convicted him, nor has a plea been accepted.
And the issue is, in talking, he waived his right to remain silent. And so there's questions about, the decision making behind his waiver, and whether he was capable of making such a decision and whether he was doing so voluntarily.
Oh boy, I love that this trial basically boils down to, in the absence of a proper state apparatus to take care of mentally ill people, uh, do the constitutional rights afforded to you accidentally afford compassion? Let's see as you drop down the giant, unfeeling Plinko machine of the state, and we'll find out.
So it's not that he made a confession, it's that he waived the Miranda rights, and he might not have been in the right mind to understand the Miranda rights, even though he walked himself to the court to confess.
Correct.
Yeah. Yeah. And we're gonna argue.
All right.
Yeah.
Either side of that issue. Any other questions before we get to the next part?
Now, stir me up with emotional arguments. I'm ready to argue.
Well, I think with that, we're going to start with the petitioner's argument, and that is going to be Jarrett on behalf of the state of Colorado. And Jarrett, I am putting 7 minutes on the clock, and it will start when you do.
Thank you very much. Mr. Chief Justice, and may it please the court, though we concede that the defendant has a diagnosed mental illness, the actions of the state in responding to his voluntary admission of guilt did not violate his due process rights. In fact, I intend to show that the officers took great pains to protect FC's rights at every step of the process, and that is what due process rights are all about. To start, the state did not seek out FC. He was not wanted for questioning or a suspect of any kind. Instead, FC approached a uniformed police officer on the street minding his own business and asked to be arrested for murder. FC was a free man. He was not detained or in police custody. He was just a person on the street who chose to approach law enforcement. As FC tried to confess to murder, the police officer stopped him and informed him of his Miranda rights before the conversation could continue any further. This is model behavior on the part of Denver law enforcement. To the officer, FC chose of his own free will to continue speaking to the officer in full knowledge of his rights and the risks. When a detective arrived, that detective again informed FC of his rights. At this point in the interaction between FC and law enforcement, FC had been informed of his rights twice, and after both times chose to waive his right to remain silent and his right to an attorney. The information that FC provided to the officers over the course of the investigation was accurate. A girl had been murdered, and FC knew the details, including the exact location of her body. So in any other case, all of this care to inform the defendant of his rights and confirm his understanding multiple times would be celebrated. The defendant would be held accountable for their actions and their confession admitted into evidence. But in this case, the defense argues that the actions of the officers were somehow not enough to actually protect FC's due process rights. They argue that he was compelled by his mental illness, and so it was not free will. This interpretation of due process rights is troublesome. There are many reasons that one may be compelled to confess to a crime that they committed, and it is not the business of the government to decide whose reason is valid and whose is invalid. Could a religious man, having spent years in a system that reinforced over and over again the requirement to confess since they were a child, claim that their confession was not truly free will? Could they say that they had been driven to confession by external forces or indoctrination? It was not their desire to confess, but a compulsion which ate at them. Did not the teachings of their God compel them above their own wishes? It needs to be made abundantly clear that having a conscience that drives you to do the right thing, no matter what its source, is not legally distinct from free will. The issue of this case is whether the government acted inappropriately, given the scenario presented to them. It is our belief that the officers involved took great pains at every step to ensure that FC was informed of his rights and understood his rights. The reason for waiving his rights is known only to FC. The Constitution protects FC from the government. It does not protect him from his own reasoning. You should also consider that according to the American Psychological Association, at the time that this case happened, in the period when this case happened, Less than 1% of people who have commanded auditory hallucinations actually follow those commands, and only some of those people are following commands that contradict what they already wanted to do. Again, that's from an amicus brief from the American Psychological Association at the time that this case took place. Therefore, we believe that FC's confession was not forced out of him by the government, and so it is not a violation of his due process rights to use his confession against him in a court of law. I yield to questions.
Man, that was compelling. Compelling evil. Usually you're on the short end of the stick in terms of having to argue in favor of evil, but I find little fault with what you just said there. Like, this case would be very different if he had not initially marched himself to the police station to kick off this chain of events. I'm struggling with that part. It really does feel like he abrogated his own rights.
Yeah, I don't have any factual questions.
Hypotheticals or deep-seated feelings?
Well, a lot of yeah, but they don't have anything to do with this case.
Sure.
Plenty of those.
I mean,
that's a different podcast.
I'll reserve my time. Otherwise, I don't know how much time I have left, but
I wonder if there is a threshold, definable or subjective, but at which the police would basically be like, no, this guy is too out there. Nothing he says, we're not even going to record what this guy's saying because until he gets a lawyer, because like it would be irresponsible of us to even attempt to make the argument that we're making now, right? To even like force the legal system to consider whether this guy's testimony was made under duress or not. Like, is there a threshold at which the things this person is saying are so outlandish that the police decide, like, you know what, we're just going to let his lawyer handle this?
Certainly. Yeah.
So
go ahead. Sorry.
They got the lawyer after, like, he drove them to where the body and all that was, or?
Yes.
On the other hand, it is kind of hard to ignore that chain of events.
So he waived his right to the lawyer. He was informed that he had a right to remain silent, that anything he said could and would be used against him, and that he had the right to an attorney. And he said, I understand, but I have to get this off my chest. Multiple times he was informed of this. It wasn't until after the confession that he began to exhibit any behavior that would make anybody question his mental state, which, we don't know what his mental state was. It could very well be that after he confessed, he did decompensate. But
I killed a girl, and I'm going to show you where I buried her is totally normal mental state.
I mean, you could have just had like really, really guilty conscience that I mean, he was considering potentially suicide or confessing. It might have just been, I mean, even if it's like, I guess there's something to be said for the stress involved with that finally getting to him. But like, the whole compel thing, it's like eating at him. Like, I feel like compel is almost either you're in a mental state where you're totally discombobulated and like, okay, we just don't listen to you. But things like, I'm just racked with guilt and I can show you where the body is. And okay, you said the Miranda rights. Like, I wonder if, and then I could see a crash coming after the adrenaline or whatever.
Like, oops.
Spikes down. Actually, here's a factual question. At any point in the process, from the beginning through the end, did he ever talk on it again or appear in court again? Did he ever recant his confession or anything like that?
My understanding is, and I understand I'm at time, so I'm just answering the question as it was asked. My understanding is everything went through I assume everything went through his lawyer after that point, and so we never really heard from FC again once he was committed to the state hospital.
My presumption would be that once a lawyer got involved, the lawyer was like, stop
Shut
talking.
up. Yeah, okay.
Stop talking forever.
But to your point, did he recant? I don't believe that happened either. And I'm not sure that a plea was ever entered, so we don't even know if... Well, it might be, and I just don't have that information in front of me.
Gotcha.
All right, we're just taking for granted that he actually murdered this woman, and like the twist is that it was just a wacky set of misunderstandings that led to this point. Like,
Yeah, I feel like
will you tell us at the end whether or not he actually did it? Because I'm dying to know.
yeah, I feel like this would be a whole different thing if he was talking nonsense and led him on this goose chase and like there was nothing there. But the fact
Oddly
that
specific, yeah.
yeah, and there's like the other corroborating evidence, with scene at the family function and all that.
Yeah, that's it for me.
All right, so is it my turn? I miss Sarah.
Yes, it is your turn, and the justice who is always most open-armed for you is not here to protect you this time.
Oh, you don't like this profound masculine
You
energy?
got to actually work for it this time.
All right. Now I feel like I understand a little bit more what it's like to be Jarrett.
Yes, welcome to my world. I have 7 minutes on the clock for whenever you start.
Okay. Mr. Chief Justice, and may it please the court. The court has previously held that a decision to waive a fundamental constitutional right is a very serious decision. As such, the decision to waive has to be knowing, intelligent, and voluntary. That is, the person has to be informed of their rights. They must have the capacity to understand and to use the information about their rights to make a rational decision. And they have to make the decision freely without being subject to coercion. Even if police are not using whips or physical injury to extract a confession from a suspect, psychological pressure also impacts the voluntariness of a confession. Keep in mind that the police uniform, being in police custody, and being interrogated are inherently coercive. At this point, the world has shrunk to the interrogation room. The room consists of you and a police officer or multiple police officers who hold the full force of the law. This court has also previously ruled that a defendant's mental state can impact whether a confession is voluntary. It goes to follow that the individual who is unstable in their mental status is vulnerable, including to real or perceived pressures, suggestion, and coercion. All of this, the full circumstances, must be taken into account when considering whether a confession is truly voluntary. In this case, it wasn't. If a confession is not given with full understanding, knowingness, intelligence, and voluntariness, then taking it and using it at trial for the purpose of depriving the individual of their liberty and subjecting them to criminal penalties undercuts the basis of a fair criminal trial. Even if the police did not engage in direct misconduct, the subsequent admission of the statement and using it as evidence against him is the government wrongdoing at issue here. The Colorado Supreme Court had it right in ruling that the admission of involuntary statements not made with the defendant's full free will and rational intellect and admitting them into evidence is a government act that violates the Due Process Clause of the 14th Amendment. This is not a matter of conscience. FC had a serious chronic mental illness. The evidence shows that he was not taking medications. He hadn't for months, and he was actively symptomatic at the time that he approached his officer and made his statements. He confessed because it was his belief, his delusional belief, that God was ordering him to, and he had to or die. This suggests that his mental illness was applying pressure that he was not in control of, and so his confession was not voluntary. The fact that he was following the commands of voices produced by his mental illness also raises questions about the validity of his confession. Indeed, he was shortly thereafter determined incompetent to stand trial due to this mental illness. So, if he is incompetent to stand trial, meaning he is incompetent to navigate the criminal trial process and to make the decisions that are expected of criminal defendants. This means he could not have knowingly, intelligently, and voluntarily waived his fundamental constitutional rights most relevant to this process. Once again, the admission of his statements, this taking advantage of his vulnerability, thus offends the dignity and the integrity of the court and its proceedings. And with that, I'll yield I'll take questions.
offends the dignity of this court is a little strong. It's just an opening thought.
I was trying to be like Jarrett.
So I do have a question. What legally defines coercion?
So basically, if there's some sort of misconduct that induces somebody, to engage in some sort of behavior that's not fully voluntary.
So what is the case for coercion here? Because it seems like the cops did the whole Miranda right thing twice. So I'm just curious, what is the argument for it being coercion?
So in this case,
but so you said the argument was like the police had done something wrong. I'm curious, what would have been the right thing for the police to do?
So in this case, the government wrongdoing was actually not so much the police, but of the court or of the prosecution seeking to enter his statement into evidence and to use it against him.
Just for clarity, the statement that he voluntarily gave, the prosecution was in the wrong for entering the statement that he voluntarily gave into evidence.
So it is our assertion that it was not voluntarily given. He was following the commands of voices that were produced by his mental illness. He was following those commands. And that was the compulsion.
What evidence would be proper to enter into court in this case?
A freely given voluntary confession by someone who was competent to make that decision to waive his Miranda rights and to provide a statement to police in the absence of his attorney.
What about the other evidence about him knowing where the body was and the other evidence from his mom receiving the payment and him being at the function and them seeming to have traveled together? Would that also have to be thrown out, or would that be viable evidence?
So anything that comes from the improperly admitted statement would have to then be tossed. So anything that the government used to try to further build a case against him that has its roots in the original statement.
How do we solve this murder?
Well, the police are expected to be investigators, and we don't want a legal system that is predicated entirely on confessions, because then that leads to undue weight on confessions and basically this undue reliance on confessions that would then introduce a sort of incentive to pressure people to confess.
What about a confession with a complementary accompanying corpse?
I suppose the police can. Well, perhaps Your Honor could rephrase so the guy brings the corpse with him.
I mean, I'm not being prescriptive here. I'm just saying, like, a confession in the absence of an actual dead body is one thing, but a confession in combination with a corpse that matches the material, contents of said confession. I don't know.
Yeah, let's say he says, I just killed somebody and there's a fresh body over in that dumpster over there.
Well, it would be
and there's a dumpster and there's a body and there's blood on the guy who made the confession that matches the corpse, but then it's ruled that the guy was insane and wasn't in the right mind to waive his Miranda rights, even though he's covered in the blood of the recently found corpse.
So
it's a little bit going over the top, but
the blood would be physical evidence that would be independent of a statement that was provided. So the statement perhaps might not be usable, but officer observations, direct observations, and any physical evidence, it would be up to the police to establish a direct link rather than relying on circumstances.
Just to jump in real quick, time was about a minute ago, but the questions keep coming.
Mm-hmm.
How about one more question, and we'll call it an end.
Graham,
what would stop me or somebody else from doing the same and getting away with a murder in this instance by just confessing to the nearest police officer I saw and then saying that I was coerced into doing so? and therefore all the evidence the police find is inadmissible in court. I mean, I'm kind of agreeing with Mike's question, which is how do we solve this murder? Where does this end?
So
It's funny we're on the same wavelength because I'm like writing notes. I'm like, I know how to get away with murder.
So if there are assertions about your mental state, then obviously that would be grounds to refer for an evaluation from a qualified professional who can engage in clinical observation, evaluation, and review of your past records and gathering of additional data to provide an informed opinion to the court with regard to whether you have a mental illness or any clinical reason to expect you to have any impairments in your ability to make knowing and informed decisions.
And time. I let that go because it was actually only helping my case. Oh, was that your honor? No, I'm fine with this. She can keep digging. It's cool. But yeah, no, that's it for arguments, I'm afraid.
I like to say that I do not appreciate being on the cop's side. Screw you people.
Yeah, so at this point, the judges can deliberate, and we will now become clerks. And so any other factual questions, things of that nature, we are happy to answer.
I had one that's maybe a stupid question. You said that he wasn't fit to be a criminal defendant. Is there another version of that for someone who is not mentally fit to stand trial? Besides like Arkham Asylum
Sorry, could you say again?
Well, he said he's not fit to be a criminal defendant. But if there's a lot of evidence that this person could have done this thing, is there another category of defendant he can be?
I mean, the option is really to refer him to treatment and to wait for him to be restored to competency, if that is even possible.
It would not matter, though, because he has already confessed and the cops already investigated, prompted by said confession. So if the confession is no good, it doesn't really matter whether he's competent later. The police don't have any evidence. And it's not like they could say, okay, well, we'll pretend we didn't go get it in the first place and we'll just go get it again. It's like, no, it's all gone.
Oh, I thought he was asking, like, what if there was evidence, but the person was also unfit? Like, then what happens? And it's like...
But that does bring up another question. Like, so they have this evidence and it leads down a path. But in this case, they would just have to throw all the evidence out and just be like...
Yeah. Mm-hmm. It all derives from the confession.
The term of art here is it's all fruit of the poisonous tree.
That goes pretty hard.
Yeah, metal.
That's crazy.
This is annoying because I get the spirit of the law and generally I agree, but I don't know if it fits in this particular case.
I'm struggling because at some point we have to like parse a definition of how crazy you need to be to not be able to abrogate your own rights. Like if I go do something bad and I'm arrested and they say like, here's your rights, you have the right to remain silent, I can be like, no, I'm going to talk about being a sovereign citizen and give you guys a bunch of ammo to prosecute me. And that's totally fine. Like I can do that. But there's a certain threshold of like not well that I have to be for that suddenly to, not be okay. And that feels slippery. That feels real slippery. Like a slope that I'm trying to slip up. Yeah, I don't know. This is a tough one for me. I'm all about limiting the power of the police to destroy your life capriciously, but like they kind of tried. And this guy's like, no, let me show you where I buried her.
Yeah, like I feel if it came to nothing, it's one thing, but the fact that it seems to have led to like so much evidence, and then it's like, no, we just got to pretend that didn't happen.
Like if he spent a year in prison over this while they waited for him to be sane and it turned out to be nothing, like that would be a violation of his rights. But like there was an actual corpse involved. So until you pull this twist out on us that it was actually he witnessed somebody else kill her, and that's how he knew where she was. And then his delusions made him cop to it, because I know you're just itching to teach us a lesson. I can feel it.
Yeah, but I'm wondering about the coercion thing. Just seems, as not a mental health expert,
It doesn't
or a
feel
lawyer,
like coercion.
It just doesn't
Yeah,
feel like
agreed.
coercion fits in this case. Like, I can see so many times where I'd be like, "That's coercion." I have a hard time wrapping my head around it in this particular case, and I could be. Someone could probably come back and tell me why I'm wrong, and I'd be like, "Okay, that makes sense." But right now, I can't get it.
It's funny because Nikki made a point in her argument to mention that the police, it's the uniform it's part of the whole coercive deal. You know, you go into a police station and, you know, everything is kind of set against you. But in this case, it kind of feels like the police uniform is the reason for the season. The only reason he went to that specific person is because they were wearing a police uniform and he confessed. And so, yeah, I'm having a tough
Yeah.
time with the
And
coercion.
it seemed like there were multiple steps before they actually got into the police station, where they were like, "Are you sure, buddy?" You know?
Yeah, like if they found the corpse and just started knocking on doors and this guy was being itchy and they're like, "You're coming with us," and then all this unfolded, like completely different story. But when he's like, "Sir, I'm looking for a helper," and the helper's like, what's wrong, young man?" He's like, "I killed someone." Like that's a very different
Yeah.
impetus
And the
for
cop's
the
like,
chain
"Whoa,
of
whoa,
events.
whoa! That's a big thing." When
That's
they're
a
leaving
trigger word
Miranda
for me.
rots, and then it happens twice with another. Like I don't like being on the cop's side, and damn you.
I
I feel
also,
dirty.
because we are the Supreme Court, I also am interested in what Jarrett said about this all being fruit from the poisonous tree. And I'd like to think about pushing back on that. I would be willing to consider, and I don't know what my fellow justices think, but I would be willing to consider or go down the path of figuring out, is the confession specifically what we're talking about? Does the confession specifically need to be removed? I think that there's conversation to be had there. But the confession leading to a whole bunch of other evidence that the police also find, that also being inadmissible, that is where I'm really having trouble.
The fruit of the poison tree, if you will.
Correct. Like I am on board and can see why it makes sense for us to say, okay, his confession specifically, we can't play the videotape from his police interview in court because he did not give that confession voluntarily in the moment. Even if regardless of, I'm not, as Mike said, not a mental health expert, so I don't know if I can agree or disagree about the meaning of the word voluntary versus involuntary. I don't think that that should impact the other evidence found in this case. I think that that's where it starts to go down that slippery slope. And I begin to ask the question, okay, where does this end? How is this case supposed to be solved if it appears as though the police, and I can't believe I'm saying this, did everything right? And
It burns.
it burns them.
Yeah, yeah. Like I'm kind of on the. I mean, instead, okay, we can't use the confession, but it sounds like a lead that led to evidence.
Right, like if they're trying to put him in jail just based on the weight of the confession alone, like completely different story. But I
Yeah.
just keep getting hung up on the fact that the road ended up in a corpse. I'm still waiting for this
Yeah.
twist.
With other evidence, right? Like they were seen at a gathering together soon by. It seemed like they traveled together. Like
That's true. If they
you
just
know,
found her where he said she would be, even that probably is not enough, really.
exactly
It's not
right. If it
enough.
was just
Yeah.
because we've all seen Stand By Me, you know, that I found a dead body and poked it with the stick, you know, and then maybe you have a break and you hallucinate that you did it. But there's so much other evidence that builds the case around it.
And it doesn't seem like the police knew who this person was, this unidentified 14-year-old, until after he confessed. And it, that piece then assisted in them contacting her family and seeing them leave, a gathering together and figuring out, the dental records, all of that information. And so I just have a hard time throwing all of that evidence out because he was coerced coerced by the voices.
You don't throw the fruit of the poison tree out with the bathwater, as the
I was
saying
trying to find a
goes.
way to do that.
You go bobbing for poison fruit, as our forefathers did.
It sounds to me like you all know what you're going to say, but you don't want to say it.
I hate learning things. Look what you've made me do. Question my own belief system. Can't stand it.
Unfortunately, that is correct for me. I know the way that I am leaning in this case. I could quibble about the details about if the confession versus the larger pool of evidence, the confession gets thrown out, but the evidence stands. I could be put one way or the other there.
So the question is, the whole thing hinges on his confession specifically, but then if they can't use his confession, then it starts the slope of, okay, well then none of the evidence that derived from the confession is usable as well.
Correct.
They're just making sure.
Yeah, I mean, the specific question of the case is, would entering his confession into evidence violate his due process?
Okay.
Right.
So there's no option to not enter his confession, but also enter the other evidence. Like, that's not a possibility.
Right, that feels like the King Solomon approach here, right? Yeah, like
it's the court's prior doctrine, fruit of the poisonous tree.
Mhm.
I mean, if you wanted to overturn some stuff, I mean, we can't stop you, but
oh, can we?
I mean,
Shall
who's going
I
to
don't know.
stop
I'm
you?
a sucker for precedent.
Yeah, I feel like the motto of this show is "Who's going to stop you?"
Mm-hmm. Yep, polite decorum is dead and buried. Okay, so there's no option in which the confession is thrown out, fine, whatever, but everything deriving from the confession is valid. It's all poison. If you start at root one, all roots thereafter are poison. I don't think his confession was unconstitutionally obtained. I think there's a million circumstances that would change things slightly that would make it unconstitutional and make his rights have been violated. But like the frontline agents in charge of administering the Constitution, in this case, the police officers, seemingly did everything right.
Yeah, let's see. So the trial judge said it doesn't matter that the state did everything right. And maybe it just comes down to the definition of what coercion is here.
Yeah, congratulations. You found a one that, like, I don't know how to decide this one. Usually, like, there's an answer that's obvious but painful, and, you just don't want to come to terms with it, but I genuinely can't decide on this one.
Oh, man, but you're our Chief Justice. Whip us into shape, Adam.
I'm supposed to be your beacon of reason. I'm lost. You gave me this
the
wig.
most powdered of wigs.
Most powdered. I've inhaled far too much talc, gentlemen. Yeah, I think that his confession was obtained legally. I think that evidence is admissible.
I agree.
Yeah, I kind of agree. I don't feel good saying it, but like,
despicable.
Yeah.
Now, again, this all comes down to the fact that there's just no like intake system for someone who's so mentally ill. Like, there's no equivalent to like the box you can drop your baby off at the fire station for someone who is so disturbed that they go to the length of killing someone to get intervention before they get swept up into the legal system and become a murder defendant.
Just also want to point out that there is no assertions regarding the motivation or the connection between the mental illness and the killing.
Yeah, he was probably fine, but he could have been fine when he did the killing.
It was not addressed, taken up by the court
Okay, yeah, that's
Whatsoever.
fair. I
Yeah.
made that leap of inference,
Yeah.
but I
Yeah,
was
I
assuming
guess-
they were connected in some way.
I can see so many ways where coercion makes sense, where it's obviously a crazy person, they get taken advantage of, and they
Mhm.
get thrown in the back of a car real quickly, and they're taken to the station, and
They
you
go
know,
to his
they're-
house
they're-
and pick him up there.
or
Like,
they're like
yeah.
intimidating, but like it just feels like that didn't happen here unless there's something I'm completely missing.
It sounds like the only reason that we're even talking about this at all is because he walked up to a police officer and told the police officer, I killed someone.
And I would have gotten away with
Yeah.
it if it wasn't for my voluntary confession numerous
No.
times.
Not only did I kill
Yeah.
someone, but I know who she was, and here's where the body is, and here's where we traveled from, and
If anything, he was coerced by God.
yeah, and how can we rule on that? Come on.
That's above this court.
You can't sue him, it turns out.
That's the real Supreme Court.
Oh, we found the one thing.
That's where all the powder falls. Pure and white.
The question I keep on coming back to is what could have been done differently by the prosecution, by the state of Colorado, by the police force. And I'm having a hard time seeing anything in the facts that were given that could have been done differently or correctly.
Yeah.
And I cannot believe I'm saying this, but if the police and the state appeared to do everything correctly, and the suspect or defendant was the one who kicked off the process, I have a hard time ruling in favor of this being coercive, and I have a hard time in saying that his confession should be suppressed.
Yeah, I think I agree.
Is there any definition of coercion, like an acceptable, like a widely agreed upon and widely accepted definition of coercion that the Supreme Court at the time of this case might have looked to, that was like widely agreed upon by the legal community? Or is the definition of coercion kind of like, you know it when you see it kind of thing? It's like pornography.
I think if it was probably just like dictionary definition.
So there's no like special like legal system definition of coercion that it would not, correlate to what a layperson would understand it to be.
If there is, again, not a lawyer, but if there is, my guess is it is specific to the actions of the state in doing the coercion. For example, if Nikki was to, know or believe that I did something wrong and beat the crud out of me until I went to the cops, I don't know that her actions would tie the hands of the state.
Oh, that means I'm just free to beat up on Jarrett as much as I want. Cool. All right.
We don't
Got
do
that blank check. If there's anything we've learned today.
I realize
that is our verdict.
I realize now my mistake.
So this court's verdict is that Nikki can throttle Jarrett,
thrash him,
without repercussion.
I feel like you're all dancing around providing a final verdict.
Yeah, I think that we have a rare unanimous consent on this one. Unanimous consensus on this one. I think that we all agree that this confession was legally obtained and is therefore admissible. No poison. The fruit, delicious.
It can be packaged
Apple
as apple cider vinegar.
Yeah.
Barrel it up, boys.
The lore.
Justice Mike, Justice Graham, do you agree, or do you have any like, I agree, but also here's my caveats?
In agreement.
Yeah, in agreement. Coercion is bad. I think We need to be strict about it, but I don't see it in this particular case.
My only regret is that we couldn't figure out a porque no los dos for this case. Just couldn't fit that square in the circle.
Okay, let's take a few minutes and think on this.
Yeah, I'm sure I'll escalate with this as soon as the episode is over. I'll come up with something.
I mean, the porque no los dos would be throw out the confession to keep the evidence, right?
I think that
Make
actually
everybody
would be.
happy.
I think that's right. I think we did identify it, actually. We just didn't name it as such. Wow.
Most flexible doctrine ever.
I mean, I just think we're wise and sage.
Yeah.
Really.
Excellent. Nikki, I think we've got it.
Yeah. All right. Wow. Unanimous decision. Okay.
Give us that twist.
And so in the real Colorado versus Connelly, it was argued in October 1986 and decided in December of 1986. And it was a 7-2 decision. And the Supreme Court reversed the decision of the Supreme Court of Colorado. So they ruled in favor of the state of Colorado. So their reasoning is that the due process protections around interrogations and confessions are purely based on police overreach or torture or coercion. So basically, it needs to come from external, not from internally. So there needs to be some kind of state action for a claim of violation of due process to apply. If there was no police misconduct that directly caused the confession, there is no basis for concluding that the defendant was deprived of due process of law. And just for you guys to know, there was nothing in the record to suggest that the police were like inappropriate. Like he literally walked up to the guy and the police tripped over themselves to read the guy his rights and be like, "Don't you want a lawyer?" Yeah. So if the police had exploited a suspect's unstable mental status to extract a confession against their will, then that would render the confession involuntary for court purposes. But if the court was basically like, look, if the police didn't do anything and then we were to say that this confession is involuntary, it would be inventing, quote, a brand new constitutional right. And then it would mean that, quote, courts must divine a defendant's motivation for speaking or acting as he did, unquote. So as long as a confession was voluntary, it can be considered given under free will as far as the Constitution is concerned. So the Constitution is only talking about what the police are up to in getting a confession. And if the police aren't doing anything, then it really kind of doesn't matter. And then during the actual hearing of the case, there was a lot of questioning about, well, what if, the guy's brother-in-law had beat him up and made him go to the police? Or what if the guy was really religious and the priest was like, oh, you got to confess. And he'd grown up in in sort of with the expectation of confessing, that sort of thing. So that was the main opinion. And then there was a lot of, it looked like people were mostly agreeing, but then there were some extra little notes. So Justice Blackmun, there was some discussion of the state's burden of proof for proving that the defendant waived his Miranda rights. So the Supreme Court said that the state of Colorado was expecting too much. They wanted the prosecution to prove by, I think it was clear and convincing evidence that the guy waived his rights. And the court's like, you don't got to do all that. Just, preponderance of the evidence. It's more likely than not. And the one justice was like, why are we even talking about this? Let's just stick to the main confession issue. Justice Stevens also agreed that, it doesn't violate the Fifth Amendment. They're not the product of state compulsion. However, he said that once police took him into custody, then they have this fundamentally different relationship with him. And at that point, they shouldn't have continued questioning him without giving him a lawyer, because basically he wasn't competent to waive his right to remain silent.
I was kind of saying earlier about is there a threshold by which they recognize that he's so out there that this guy needs some assistance from legal counsel?
So I wonder if part of it was because the guy presented really well initially. He held it together and then he fell apart afterwards.
That seems like a sane, upstanding murderer. We should listen to this.
Yeah, if he'd been really disorganized and whatever from the beginning, I think that would have changed the approach and the treatment.
Yeah. Also, Justice Stevens. So this must have been fairly contemporary.
Yeah, 1986. So 39 years ago. And then let's see. Yeah, Justice Brennan also he had some issues with this because he was like, look, the guy wasn't well, and he went and like made a bunch of decisions that, basically led to the deprivation of liberty. And he was like, a confession by somebody with a mental illness shouldn't be considered voluntary just because the police didn't do anything. Free will and reliability are really important in deciding if a confession should be admitted. So the court really does need to investigate the circumstances around the confession, and police behavior is only one part of government conduct that should be considered. And then he was like, yeah, this guy had a mental illness. And so if you're taking this confession with a person with a mental illness, then this raises questions about the reliability of confessions of a whole. You have to make sure that the confession is valid. And he threw in a line because actually, I think you guys had a little bit more information than the real life justices did, because he was like, the record doesn't show whether there was any corroboration of this confession by other evidence. And he was kind of upset about it until, and Peasy wrote a whole article where he was like, no, this is what really happened. So, but basically the thrust of it is, if the cops aren't doing anything to you to make you talk, then whatever reasons you have for talking to the police are your own, and you can just deal with the consequences.
USA. Isn't that what freedom's all about?
Vindicated. I thought you were going to come up with some random twist that was going to make me feel like a complete shithead for having the beliefs that I did about this. I was like, oh no,
Yeah.
what are they going to drop on us?
Right. You beat up on the mentally ill and you're a bad man.
Yeah. Oh yeah. No, he said it, and then it turned out DNA proved the real guy, etc. No. In this case, the police did, follow up, and they did a lot of investigation and like got themselves a solid case. It's just that the defendant couldn't be tried for it initially. But as we said, again, he was deemed competent after he got treatment. And according to Peasy's article, let's see. So after SCOTUS made this decision, they resolved the original criminal case, so the killing, by a plea bargain. So it was 1987. He pled guilty to second-degree murder in return for a sentence of 12 years and 1 day in prison. At that point, he had been held in custody for over 4 years while the case was pending. So he entered this guilty plea. The judge accepted it. He stayed in prison for another 1.5 years, and then he was released. So at that point, he'd been in custody for 5 years, 10 months, and he ended up getting paroled in Colorado. And maybe 2.5, 3 years after that, the spring of 1990, he completed his parole and then left Colorado and returned to Massachusetts because that's where he's from.
Oh, of course.
So, and then, as just some other side notes, so Melton and colleagues noted in their book that came out in 2018, the most recent iteration, that psychological research essentially shows that even people who think they understand their Miranda rights well actually don't. And even if people appear to understand the warning, there can be some concerns and questions about interrogation strategies that are commonly employed by police that can lead to false confessions. So that was just some notes. And then Jarrett made reference to the American Psychological Association's stance on command auditory hallucinations. So they published an amicus brief for the court to use in making this decision. And their stance prompted some disagreement because they had a very conservative estimate on the proportion of people who act on command auditory hallucinations. So they said it was less than 1%. More recent estimates suggest that a substantial portion of individuals who hear voices actually comply with the commands. And so ranges go from like 40 to 88% or more. But, it really depends, like the extent to which hallucinations can influence behavior. It gets connected to a lot of different factors. So like the amount of distress that they cause, whether there's other symptoms going on at the time, whether the voice is perceived as malevolent or benevolent, whether they perceive themselves as powerless in relation to the voice. if they think that they know who the voice is, or they can assign an identity to a voice, that can have an impact. The nature of the command, because a command hallucination, I mean, I guess it can say confess to murder or hurt someone, but a lot of command hallucinations can just be like brush your teeth, and you don't, so like you hear that, like, it's kind of a low stakes decision, and actually brushing your teeth is a thing that dentists want you to do for your own health. So, and so, and then it gets difficult to, and then if there's like congruent delusions going along with it, their feelings about not complying, and people can vary as to how compelled they feel, to follow what the voices say. But this is difficult to study in part because this involves self-report, and studies are complicated by lack of generalizability, small sample sizes, variations in operational definitions, the usual science issues when you try to make a definitive pronouncement about human behavior.
Next week, Mr. Connelly goes in front of the Senate to be confirmed as Attorney General.
Yes. This is why I said in my argument that according to the APA at the time of this case, I didn't necessarily want to ascribe that to present day thinking, but also I couldn't tell you the date. So there you go.
Yes.
Of the 100 people who hear voices, only one of them actually acts on the voices. Seems
I do most
unlikely.
Of what my voices say.
Unlikely.
Yes.
The most fascinating thing I ever learned about schizophrenia is that, and this is hearsay that I read on the internet, so I can't source it, but apparently people in other cultures outside of the United States have a much higher incidence of hearing schizophrenic voices that are encouraging, or like, generally affirmative. And in the United States, you're far more likely to get voices that tell you to do bad things and bring you down and tell you you're worthless. Isn't that fun?
Yeah, culture, religion, all of that stuff.
It's the fluoride.
The fluoride.
Yeah. Is that a situation where it's like, it's funny how only Christians ever seem to get possessed by the devil?
That's exactly what I was thinking when you were saying that.
That's true. I've never heard of a Scientologist getting possessed by the devil.
Yes.
Specifically.
By a Christian deity.
Yes, by the Christian devil, Mephistopheles. Yes.
I also like how there's a gradient of the voices. Like the voices that tell you to brush your teeth, like that, you're fine. It's, there's a threshold where the voices tell you to do some shadier stuff where
It's a helpful voice when it tells you to brush your teeth, but suddenly when it's like, hey man, tell the cops that you killed somebody, it's just like, whoa, hold on, voice.
Well, yeah, but what if you did kill somebody? I mean, that could... Okay, so actually this is an interesting question. As someone who I don't think has had voices, what's the difference between hearing voices and just like your inner monologue? I hear my own voice talking in my head all the time.
Ultimately, I was kind of thinking the same way the justices ended up thinking on this one, where it's just sort of like, I want all the protections that could possibly be afforded to me from the actions of the state. But what are the police to do if they have no leads and then somebody comes and gives them a lead and they just start doing what they do? And then it turns out that, at the time the person gave them the lead, unbeknownst to them and impossible for them to have diagnosed or seen, it ruins the entire case. And it really puts the state in an impossible bind.
It's almost exactly the same as the case from last season that I cannot remember the name of, but we decided basically that the state has no obligation to proactively go out of its way to try to protect people from themselves or from their loved ones. Like, the state can't proactively go try to protect their child.
v. Winnebago.
Thank you.
Which I referenced in my argument. I said, you're entitled to protection from the government, but not from your own internal reasoning. And the government can't be an arbiter of your own internal. It can be, there are psychologists and psychiatrists who get involved in the legal process and help with that. I also feel like this case is a bit of an edge case. It is a very particular circumstance. I think all of the justices would agree that, like, and you even said it yourselves, right? It's like, if just one little bit of this case was slightly different, I would have a completely different way of thinking about it. It's just
they brought out the nightsticks in the confession room, give him a little beat down. Like, then we're talking about a different case altogether.
Batman comes out of the shadows, smashes his head on the table, you know.
Right? Like, just gives him a devastating cranial injury just so they can get to the bottom
Yeah.
of this.
Clearly, that can't be admissible in court. But I will say that there is one thing that gives me pause, and this is a feeling that I'm beginning to develop as we do more and more of these episodes, because I feel like the Fifth Amendment and the 14th Amendment understandably come up a lot, right?
Mhm.
Due process, right? I do wonder if we think of the timing on this case, this is like the mid to late 80s. So this is not that long ago. This is in the lifetime of just about everybody currently on this podcast episode. And it does feel like perhaps previously, in previous generations, the idea of your due process rights was a lot wider. By which I mean, I feel like maybe justices had wider latitude to tell the state, okay, I understand the wider the ideas, I understand the case law, but I'm also going to take into account this particular case that's in front of me right now. And it feels like every case that ends up in the Supreme Court is further limiting what the trial judges have as far as latitude. And it's sort of this like, okay, originally there was 1,000 things that could happen or an infinite number of things that could happen. And every case that comes before us, we take one away and we further constrain and further constrain. And, and so I am beginning to wonder if the concept of due process is becoming very letter of the law, not spirit of the law. And that concerns me a little bit, but
Yep.
but it doesn't change my opinion on what the outcome of this case probably should have been.
Yeah. And yeah, I think part of the issue with this case was the guy, once again, presented really well, because, and that can happen, actually. Symptoms can wax and wane, and people, especially with motivation, can try to pull themselves together and look good.
One thing I do also just want to add is I believe it was Brennan's dissent where he basically said, oh, so a guy comes in and confesses and they don't even like have any evidence around it. It's just they're going to accept this guy's confession, and then it turns out he's got schizophrenia, and we're still just going to like go ahead with that. So in the article that I used for the facts of the case written by Pizzi, he makes it very clear that the case that made it to the Supreme Court didn't have all of the information the police collected after the confession, because that wasn't necessarily relevant to the constitutional question of whether or not the confession was admissible, because that question of what was happening at that time and the investigation was later. Also, apparently, the trial judge who was involved, the prosecutors, the defense, they all had that information and none of them disagreed on what the police found. So it wasn't important to them in their arguing when they went to the state Supreme Court and then the actual Supreme Court. So the Supreme Court justices felt like the cops, arrested the guy on his confession and then that went to trial. And Pizzi, in his writing, wants to set the record straight because this has become kind of a thing that comes up with this case a lot when people think about it, or when it comes up in popular culture. Is wait, so he said he was guilty, and they were just like, okay, and and no, the cops put in a ton of legwork. They sent officers to Boston. They pounded the pavement to figure out who this woman was who had been murdered, and the connection between the defendant and the murdered girl. Like, there was a ton of work. So when you look at, so when we could presented it to you, you had all that information to know that, like, not only did he confess, but the cops corroborated all of it.
Although, yeah, if that information hadn't been included, that would have been such a sticking point, I think.
Yeah.
For this court session. Yeah.
Did he
Yeah.
end up getting prosecuted for the murder?
Yeah. He ended up being well enough to plead guilty, and he served a total of like 5 years, 10 months.
I thought it was 14 years.
No. He was sentenced to 12 years in one day, but after he did the plea and it was accepted, he only served another, I'd say like year and I can pull it up.
Right. You said a year and a half, or
a year and a half, and then he was released. And there was a whole thing about where
And
was
he
he going to
was-
be paroled.
And he was in custody for 4 years waiting for the whole thing.
So
was
he
never-
did.
Right.
Yeah.
He didn't have bail or anything like that. Another thing that I feel like we need to mention is that just having a mental illness does not make you a criminal. So,
Correct.
just a reminder, there are a lot of people who are suffering, and suffering is the exact correct word to use with schizophrenia. And people with schizophrenia are not murderers. They are people who are suffering from a mental disorder. And, plenty of people are murderers. It's not the schizophrenia necessarily that makes the murderer.
Murder is an equal opportunity employment opportunity.
That's what I'm getting at. Yeah,
Yeah.
I just want to make sure that we're not continuing any stigmas that would be inaccurate.
Yeah. Violence happens for a very wide variety of reasons, and it's actually a really small proportion of them that are attributable to mental illness specifically.
As far as from a society, how does this impact us, our day to day? I think another one of my so whats is something that Adam hit on almost immediately, which was like, there's a mental health system that could have probably multiple places along the line been an intervention that either would have stopped the murder or made it so this individual was healthy enough to present his confession without all of the cloud around it.
I question whether that was. If he was transient, then no public mental health system would have been able to, to snag him.
But he wasn't transient. He was a full-time cab driver in Boston.
Oh, really?
Yeah.
Oh, interesting.
He was well known around the neighborhood. Everybody knew him.
Oh,
Yeah.
okay.
I think
But also,
at some point, didn't you say that, he was not taking his meds, so he had some care at some point and had medication?
Until he dropped out. Treatment is fully voluntary, and in America, if an adult does not want mental health treatment, they are absolutely not getting it. All right. So, in sum, today, the Adam Court has decided that the police are awesome and wonderful and are right in every single thing that they do.
And that is my catchphrase.
All cops are awesome.
Yep.
And on that note, we're going to leave off here, everybody. And thank you very much for your time. And so thank you to Associate Justice Graham.
I'm just happy to be here. I'm just happy to be so pro cop on this episode. Happy to be here.
Associate Justice Mike.
I missed the horse poop.
And our Chief Justice Adam.
I'm just glad anyone cares about what I have to say.
We're glad that we didn't just enrage all of you with, whatever horrible thing is going on in the law today.
It's the internet. Somebody's
Speak for
offended.
yourself.
So with that note, Jarrett and I are going to end things here. Thank you very much, everyone.
Play us out, keyboard cat.
Thanks all.
Well, there you have it. By unanimous decision, the Adam Court decided the confession was voluntary and can be admitted. That's it for this episode, but before we go, thanks again to my co-host and to our justices. The music in this episode was written by Studio Columna and Toby Smith and provided by Pixabay. Audio mixing and producing was done by Jarrett. Research was done by me. Thanks for listening. Please subscribe, rate, and comment so other people can find us. You can also catch us on YouTube, Instagram, and Blue Sky. Our handle is @RelitigatedPodcast. Please help us spread the word. Until next time, I'm Nikki, and this has been Relitigated. Bye.